Thank you for joining me for my video series. I hope that you will find the content educational. Check back for more on topics related to estate planning. So starting with the basics, what is a will? A will is a document where you say who gets what and who's in charge of making that happen. Someone named in a will to receive your assets is called an heir or a beneficiary, and the person put in charge of making that happen is called a personal representative or an executor. It's important to note, though, that wills do not apply to assets where you have a surviving joint owner of that asset or to assets where you have a living beneficiary designated. For example, on retirement accounts and life insurance, if you have a spouse named and then perhaps your children, then that asset will be payable directly to the living beneficiary who's named, separate from what a will says. If you have a will, and a will is really critical for your estate plan, you need to make sure that it's in sync with everything owned jointly and also everything where you have a beneficiary named to make sure it's all working together according to your wishes. Also, for any property passing under a will, it's important to note that a will has to be filed with a probate court and reviewed and approved before anyone named in the will, the personal representative or otherwise, can act on your behalf, gather your assets, or pay any creditors who might be owed money, and then ultimately distribute the assets to your heirs or beneficiaries. A will is a document that does have to go through probate, which is actually a common misconception we run across. People think that a will is a magical document that covers every estate planning scenario, and it doesn't. It's critical and you need it, but you need to make sure that you understand it goes through probate before it is effective, and that is a will.